And today class is beneficial construction. This is the online class, and this construction, beneficial construction, is a second year, second semester topic under the caption or under the subject interpretation of statutes. Let us see. The beneficial construction is also known as a liberal construction. It means interpretation of statute in the widest possible meaning of the language permitted. The mischief in the language is remedied by the liberal and beneficial construction. Beneficial construction is an interpretation to secure remedy to the victim who is unjustly denied the relief. Such beneficial construction is mainly applicable in social welfare and labor legislation. I repeat, such beneficial construction is mainly applicable in social welfare and labor legislations. Let us see how the rule of beneficial construction will work. If the natural meaning of the words are not able to achieve the object of the statute, or extended meaning may be given to them if they are capable of receiving that meaning. If in legislation the general object is to be benefit a particular class of persons and any provision is ambiguous so that it is capable of two meanings, one of which would preserve the benefit and another which would take it away. The meaning which preserves it should be adopted. I repeat, if in legislation the general object is to benefit a particular class of persons and any provisions in ambiguous so that it is capable of two meanings, one of which would preserve the benefit and another of which would take it away, the meaning which preserves it should be adopted. Where a court has to choose between a wide meaning which in its opinion carries out the object of the legislature more fully, a narrow meaning is carries it less fully, the court will often choose the former. Beneficial construction is a tendency rather than a recognized rule. Where the language used by the legislature fails to achieve the object of the statute, a more extended meaning could be given to it to achieve that object. Many times, courts have beneficially interpreted such statutes as dealing with the jurisdiction or procedure of the court. Beneficent statutes have sometimes been called by the name of social welfare legislations, and also they have been interpreted in such a manner as would achieve the beneficial object. The Supreme Court observed that when material words can be construed in two ways, one of which is likely to defeat the object of the statute, while the other is likely to achieve it, the later construction should prevail. If the words are capable of giving only one meaning to the enactment, the meaning alone should be presumed to be the intention of the legislature. It was held that the provisions was inapplicable in situation where a degree of enactment already been obtained by the landlord. In the case of the Baldev Sahai versus R.C. Bhasin, the tenant who was living in the house with his parents, two sisters, and brother left in India to permanently settle down in Canada, leaving his mother and brother in the house who keep on paying the rent regularly. The landlord filed an application of ejectment of the tenant on the ground of non-residence of the tenant under section 14, subsection 1, clause D and clause E of the Delhi Rent Control Act 1958, alleging that his mother and brother could not be treated as a member of his family. It was held by the Supreme Court that the word family must be given a wider meaning so as to include not only the head of the family but all members or descendants from the common ancestors who are actually living with the same head or depending on the same head. The enactment, a beneficial provision, must be meaningfully constructed, I beg your pardon, the meaningfully construed so as to advance the object of the act, and curing any lacunae or defect appearing in the same naturally, therefore, family is included near relations of the head of the family, including mother and brother. So a liberal interpretation is given, a broader interpretation is made in this case law. In the case of B. Saha versus Presiding Officer, where Section 5 of the Maternity Benefit Act 1961 was in question, where an unexpected mother could take 12 weeks of maternity leave on full salary. In this case, a woman who used to work 6 days a week was paid for only 6 into 12, that is 72 days instead of 70 12, that is 84 days. Supreme Court held that the words 12 weeks were capable of two meanings, and one meaning was beneficial to the woman, that is 7 into 2, 84. Since it is a beneficial legislation, the meaning 84 days salary that gives more benefit to the woman as Maternity Benefit Act is a welfare and remedial legislation, so beneficial interpretation is made in this case. It is said by Maxwell, the beneficial construction is a tendency and not a rule. Yes, I already discussed earlier or and the above. The reason is that this principle is based on human tendency to be fair, accommodating, and just. Instead of restricting the people from getting the benefit of the statute, courts tend to include as many classes as can while remaining faithful to the wordings of the statute. For example, in the case of Alembic Chemical Works versus Workman, an industrial tribunal awarded more number of paid leaves to the workers than what Section 79, Subclass 1 of Factory Acts recommended. This was challenged by the appellant. Supreme Court held that the enactment being welfare legislation for the workers, it had to be beneficially construed in the favor of the workers, and thus, if the words are capable of two meanings, the one that gives the benefit to the workers must be used. Yes, more number of paid leaves to the workers were given to the workers because of the beneficial interpretation or beneficial construction by the court. Similarly, in Unichoi versus State of Kerala, I repeat, similarly in the case of Unichoi versus State of Kerala, the question was whether setting of a minimum wage through the Minimum Wages Act 1948 is a violative of the Article 19, Subclass 1 and Article 19, Subsection 1 and Clause G of the Constitution, because the Act did not define what is minimum wage and did not take into account the capacity of the employer to pay. It was held that the Act is a beneficial legislation and it must be construed in favor of the workers. In an underdeveloped country where unemployment is rampant, it is possible that the workers may become ready to work for the extremely low wages, but that should not happen. Hence, minimum wages giving not against or contrary to the Article 19(1)(g) of the Constitution, that is the Indian Constitution. Another example of the beneficial construction of a statute is the Juvenile Justice Act. The earlier Act of 1986 was replaced with a new Juvenile Act in 2000, whereas the 1986 Act defined the term juvenile as a boy not having attained the 16 years of age or a girl not having attained the age of 18 years. The new Act, that is the Juvenile Justice Act 2000, defined juvenile to mean a person who has not completed the 18 years of age, irrespective of the boy is concerned or girl is concerned. The issue came up for a consideration before the Constitution bench in the case of Pratap Singh versus State of Jharkhand. The court looked into the object of the Act, which is to provide for the care, protection, treatment, I repeat, for the care, protection, treatment, development, and rehabilitation of the neglected and delinquent juveniles. Further, the Act were passed in discharge of the obligation to follow the United Nations minimum rules for the administration of juvenile justice. Since the Act is a remedial in nature, beneficial construction was given to promote the beneficent object behind them. That means, even though the offense committed before the 2000, but the definition of juvenile is taken from the Act of 2000, and thus accused were acquitted because they were juveniles according to the Act of 2000. Thus, beneficial interpretation was given in this case. That is a remedial legislation. The effect of beneficial legislation should not be construed to be defeated by subsequent legislation except through a clear provision. the right of minor children to get a maintenance from their father as provided in section 127 of the CRPC was construed not to have been taken away in respect of Muslims by the Muslim Women's Protection of Right on Divorce Act 1986, that is section 3 subsection B, which enabled a Muslim woman to claim the maintenance for the minor children up to the age of 2 years only from her former husband. It was held by the court that the right of children to claim maintenance under CRPs was independent of right of divorced mother to claim maintenance for the infant children, and former is not affected by the 1986 Act. That means here beneficial interpretation is given, and section CRPC from 125, 126, 127 also applicable to the children when the father has divorced the mother. Now let us see, in the case relating to the insurance aspect of motor vehicles, the Supreme Court held that to prove its defense, the insured has to prove, number one, breach of a condition by the insured was done knowingly or resulted due to his negligence, that is, the insured was drunken, and two, breach was fundamental and had contributed to the cause of accident, that means the insured does not have the license. It was held that even in cases where the insurer is able to prove the defense of breach of condition, it will have to satisfy the award against the insured first, but it can recover the amount paid to the claimant, that is the victim, from the insured in the same proceeding before the tribunal. That means remedy should be given first, or benefit should be given the first to the victim or claimant. Later, insurer may claim from the insured because of beneficial interpretation. In a recent judgment in the case of the Bangalore Turf Club Limited versus Regional Director, Employee State Insurance Corporation, the Supreme Court judged the ESIC Act on beneficial grounds and emphasized that the beneficent construction is being preferred to help the intended beneficiaries. Illustration on the limitations of beneficial legislation means where the beneficial legislation is a bar and the beneficial interpretation is not given to the, even though it is a beneficial legislation. Let us see. It is important to note that the principle of beneficial construction has to be applied with a few safeguards. It can only be applied without rewriting or doing a violence to the enactment. When the language is clear and explicit, it leaves a little scope for any bending of the interpretation. Sympathy cannot be a sole principle guiding interpretation. I repeat, sympathy cannot be a sole principle guiding interpretation where every time the beneficial interpretation or construction should be done. For instance, you take in the Maruti Udyog case, the Constitution bench held that no provision of Act provided for absorption of contract labor on issuance of a notification under the Section 10 prohibiting employment of contract labor. In the Employee State Insurance Act 1948, Section 53 provided that an insured person or his dependent will not be entitled to any compensation or damages under the Workmen Compensation Act 1923 or any other law for time being in force or otherwise in respect of an employment injury. This was held to bar even claim for the compensation for damages in torts, although the act is a beneficial legislation. So these are the hindrances for the beneficial legislation where its extent will not be extended. Let us see, in the Umadevi case, the Supreme Court held that those who employed on daily wages temporarily on a contractual basis by state or its instrumentalities can't be said to be holders of a post and have no right to claim regularization simply because they have worked for a number of years. This decision shows that sympathy or sentiment can't be the sole ground for passing a favorable order when there is no legal right to support such an order. The Control of Rent and Eviction Act seeks to protect tenants from unjust eviction, and it is principle that in case of doubt, such act should be interpreted to lean in favor of the tenants. However, it is a restriction that the benefit conferred on the tenants under these acts can only be enjoyed on strict compliance of statutory provisions contained in them. The beneficial legislation should not be construed such that it brings within its ambit a benefit which was not contemplated by legislature. I repeat, the beneficial legislation should not be construed such that it brings within its ambit a benefit which was not contemplated by legislature. Hence, where the insurance company had rescinded the contract of insurance and informed all the parties before the accident after the check issued to satisfy the premium due is dishonored. Yes, let me see in the conclusion. The courts must be vigilant to ensure that benefit conferred by the welfare legislation must not be defeated by subtle devices. It is the duty of the court to get behind the smoke screen and discover the true state of affairs. I repeat, it is duty of the court to get behind the smoke screen and discover the true state of affairs. It can go beyond the form and see the substance of the transaction. The strict and narrow jacket concept of law is no longer available for the purpose of interpreting a social welfare piece of legislation, especially after the new millennium. The policy of the democratic government should run in conjunction with the dynamic interpretation offered by the courts. The discussion above has shown the application of the principle of beneficial construction. It is, however, important to note that such a construction will be given by the courts only if words of the beneficial statute so disclose. There have been many instances where the courts have refused to apply the principle because the instances of the beneficial statutes were unambiguously pointing out the intention of the legislator to the contrary. The court exists for the society, and in the event the courts feel the requirement in accordance with the principle of justice, equity, and good conscience, the court must rise up to the occasion to do a complete justice and meet the expectation of the people. Thank you very much patiently listening my online classes. Goodbye.